This guide explains Washington's seasonal worker overtime pay and agricultural rights for 2026. We are using official sources from Washington State Labor and Industries at lni.wa.gov and from the U.S. Department of Labor at dole.gov. The topic map is clear. First, Washington overtime after 40 hours. Second, piece rate calculations, paid rest breaks, and meal period rules. Third, the 2026 state minimum wage and related workplace protections. Then, the federal agriculture rules that still matter, especially when duties change. And finally, seasonal worker rights involving contractors, transportation, disclosures, retaliation, and complaints. The goal is simple. Compare the promise, the hours, the paycheck, and the official rule. According to RCW 49.46.130, in the Washington State Labor and Industries overtime page at lni.wa.gov, all agricultural employees in Washington are eligible for overtime after 40 hours in a work week starting January 1, 2024. That is the rule for 2026 as well. Overtime must be paid at not less than 1.5 times the worker's regular rate. The earlier phase-in thresholds, 55 hours in 2022 and 48 hours in 2023, are no longer the active rule. For a Washington seasonal worker, the central weekly checkpoint is now 40 hours, not 55, and not 48. Washington did not leave agricultural piece rate workers outside this overtime change. Administrative Policy ES.C.6.2 on lni.wa.gov explains that agricultural piece rate employees are covered, but the employer first has to calculate the worker's regular rate for the work week. The policy says the calculation starts with total weekly compensation, including piece rate earnings, qualifying downtime pay, and rest break pay, divided by total hours worked. Then overtime is based on 1.5 times that regular rate. Because the straight time portion may already be included inside the piece rate earnings, the remaining overtime amount is often the extra halftime premium for the overtime hours. The same Washington guidance also says paid rest breaks for piece rate workers must still be on the employer's time. Break rights do not disappear just because the job is seasonal or paid by the bucket, bin, or row. On the official Washington Labor and Industries page for agricultural rest breaks and meal periods, and in WAC 206-131-02, workers must receive a paid 10-minute rest period for every 4 hours worked. They must also receive a meal period of at least 30 minutes for every 5 hours worked. If they work more than 11 hours in a day, they must receive an additional 30-minute meal period. If a meal break is interrupted, or the worker must remain on duty, the meal period becomes paid. Washington Labor and Industries also says restroom breaks are paid hours worked, and employers must provide reasonable access to toilet facilities. Washington's 2026 pay floor is far above the federal floor. On the official minimum wage page at lni.wa.gov, Washington says the 2026 state minimum wage is $17.13 per hour, and most agricultural jobs qualify for that minimum wage. The same agency explains on its paid sick leave page that most workers, including seasonal workers, earn at least 1 hour of paid sick leave for every 40 hours worked. That means a worker in Washington may need to ask several questions about the same paycheck. Did I reach at least the state minimum wage? Did overtime start after 40 hours? And was earned sick leave handled correctly? Those are legal workplace protections, not optional bonuses. Federal law uses a different baseline, so workers should not mix the systems together. According to fact sheet number 12 from the Wage and Hour Division of the U.S. Department of Labor, at dole.gov, employees employed in agriculture are generally exempt from the overtime pay provisions of the Fair Labor Standards Act. This is commonly described as the agricultural overtime exemption in Section 13, subsection B, paragraph 12, of the FLSA. But that federal exemption does not erase Washington's stronger state overtime rule. The same federal fact sheet also warns that duties matter. Some packing or storage work involving products from another farm may fall outside the federal definition of agriculture, so the legal analysis can shift from one work week to another. Seasonal workers also need to look beyond overtime and ask who recruited them, transported them, and disclose the terms. On the official U.S. Department of Labor page for fact sheet number 49, the Migrant and Seasonal Agricultural Worker Protection Act, or MSPA, covers wages, housing, transportation, disclosures, and record keeping. That same federal source says wages must be paid when due, and workers must receive itemized written earnings statements for each pay period. On the Washington State Labor and Industries Farm Labor Contractor Licensing page at lni.wa.gov, the state says farm labor contracting law provides protections such as requiring a contract, safe worker transportation, meal and rest breaks, and getting paid. If a contractor is involved, workers should verify that the contractor is properly licensed and keep every disclosure they receive. When pay looks wrong, document early and use the official complaint channels. Washington Labor and Industries says on its Worker Rights Complaints page that wage complaints, including minimum wage, overtime, and paid sick leave, generally must be filed within 3 years, while retaliation complaints generally must be filed within 180 days. The Washington Termination and Retaliation page also says employers cannot cut hours, reduce pay, or use immigration-related threats to punish a worker for asserting protected rights. For state help, workers can contact Washington Labor and Industries. For federal help, the Wage and Hour Division at dole.gov lists the helpline 1-866-4-US-WAGE. This presentation is educational only, not legal advice, but the strongest cases usually begin with saved job orders, pay stubs, schedules, text messages, and written notes made right away.